Dr. Courtney, could you please tell me why you came to court today, what you were going to tell the court if you had been given the opportunity?
That a patient of mine, as well as a patient of other cannabis physicians, has been in the state for 6 years and has been using cannabis under approval. The cannabinoids in the plant are fat soluble, they store in the fat tissue, and they last for quite some period of time. The reason it takes you approximately 8 weeks to get a clean urine is because they slowly leach out. He has been in jail for some period of time, and it's quite likely that the cannabinoids that he had in his body that he had been ingesting over the last period of time are approaching zero. And it's a matter of fact that many of these cannabinoids are antispasmodics, and his condition is bronchospasm related to asthma, and that when you lose the antispasmodic protection of those cannabinoids, you run a risk of going back into a status state in which your bronchioles can go into a spasm sufficiently long to cut off enough oxygen to produce an anoxic condition that can lead to death. And so as he continues without his medication of choice and state right, he is at risk for a sudden death due to status asthmaticus. To me, someone is practicing medicine that does not have a license, because no one would terminate an individual's life-sustaining medicines, which is what is in fact at play here. It's time that we respect the science and the physicians that are practicing behind that science, and when they prescribe something, that prescription or that approval is upheld regardless of the state or of the state of circumstances. So it's my belief that the United States Constitution allows one a right to life, as does California, and presumably the state of Texas. And so if you're allowed to the right to life, Chris Diaz is exercising that right within state law, and I wish the state of California would support its law in the face of what currently is a challenge by the federal government, but clearly is an illegal challenge. And I think now is the time for us to identify that the federal government circumvented state law by turning to a treaty as a ruse to avoid dealing with state rights. The federal government does not have an enumerated right to act in this area. The states do by residual. And so we're facing a federal crime, and they're acting on that criminal activity with a terrorist element. They're not actually bringing it into court where we could argue the case. They are just terrorizing everyone. They've terrorized me, they've terminated my banking privileges, and it's very difficult to run a small business when you can't write checks for rent and utility and payroll and employee and wages. They've violated dispensaries that are established under California law to provide cannabis by threatening their landlord with seizure of property. They have not done this, but the threat is sufficient to close dispensaries, to close down, and that's a damage, and that damage needs to be taken back to the federal government, put on their table, and paid for. And when the federal government starts being sued for its activities, then suddenly people in California will be able to have the right to the law to which they created the initiative, they voted it in place. The federal government has no right or position or prerogative to be overturning that right. And so here we have a patient who is in need of this antispasmodic protection, because after years and years of Western medicines, steroids, he gets fungal overgrowth, he's had pulmonary collapse, he's had multiple admissions to emergency room because of his very tenuous pulmonary condition. Now as these cannabinoids are completely leaving his body, his vulnerability to collapse is rising to a significant degree. And so the stress of transport alone could throw him, plus anxiety and fear of going to a state where there's zero tolerance, and the loss of his children and his ability to protect them, would put anyone in a state of extremis that in his case could result in a spasm, shuts off oxygen, results in his death at a moment's notice. And I want everyone to be on notice who's participating in this ruse that this is not humorous. This is life and death for his life and for his family's life, and there needs to be some consciousness applied to justice in this case. And currently it's one kind of legal maneuver after another legal maneuver, and justice is not just blind, but is being murdered in the background. And the people of the United States need to stand up and say, yep, this is a time for justice. And the justice is, here's a man who sought safe harbor, was approved for the use of cannabis in this state, and because he travels to see his ailing and aging grandmother and is driving with a California license, is picked up and probably illegally held, he now faces either life in sentence or death in the process of transport or upon arrival for 17 grams of cannabis that are in an extremely reasonable personal use amount that in my mind is fully guaranteed under Article 4 of the Constitution, where it says you're entitled to exercise the rights of your state as you travel about the Union. This is exactly what was occurred at this point.
Don,
Yeah.
what exactly happened in the courtroom today, starting with how it came to be that Christopher Diaz is no longer represented by a public defender who threw up his hands the day he got the case and now has a champion?
Some people on the coast who we've been through some political battles before in the 80s and 90s contacted me and explained the situation. Of course it resonated. Young guy with a very small amount of cannabis faces a very, very serious charge with a potentially long term. And I just thought that based on a little bit I'd seen and read, that not every avenue of attack was being raised to keep him from being transported in custody back to Texas.
And so what happened in the courtroom today? Ann Mormon, who shuffled the case last time round, listened to you intently. What was the exchange?
It has to do with how restrictive the law is in terms of avoiding extradition. There was a time back in the 70s and before when extraditions really were considered somewhat discretionary, that the governor of the state in which the alleged fugitive from justice was found could refuse to send that person back. This extradition matter has a long and tortured history, largely around slavery and whether you had to return escaped slaves to the states from which they had escaped. Obviously, it was thought for quite a while that a governor should have discretion not to send an alleged fugitive back to the state that's demanding his presence without some clear conviction that this was that this person really needed to be tried and that the prosecution needed to continue. That said, the U.S. Supreme Court in the 80s in particular issued a number of rulings which said that that extradition is first and foremost governed by Article 4 of the U.S. Constitution, which pretty well eliminates the discretion of any state judge to resist extradition to the demanding state. That doesn't mean that someone in Chris's position has no options. It certainly is true that we cannot challenge Texas law, Texas drug laws here in California courts. We're not even in a position to challenge the possibility would it face cruel and unusual punishment in Texas based on the potential length of the sentence or based on his precarious health. What we can do is seek to delay extradition because of his what we believe to be serious current health problems. We can also ask that he be released on bond, a more reasonable bond than Texas currently is asking for, so that he can voluntarily return to Texas and face the charges there. The charges are serious, but the fact that there's a 99-year maximum that he could face, someone in his position who has no prior criminal history that I'm aware of is not going to get 99 years, nor would I expect them to get 5 years, which is the minimum sentence if he were sent to prison. He certainly would be a candidate for probation in Texas. My feeling is that at the very least, we need to get Chris's health stabilized here. He's been declining, as far as we can tell, and based on Dr. Courtney's opinion, while he's been in jail. He's been in jail now pretty close to 2 months now here. He's already served 80 days in Texas on this thing. And I want to be sure everybody understands, he didn't escape from jail in Texas. He didn't attend a hearing that he was supposed to, and therefore became a fugitive, what we call in California failure to appear. So currently he's being held on a fugitive warrant issued under the laws of the state of California. I'm told that there's a Texas governor's warrant on the way, or perhaps what Mr. Hubley meant was that there's a California governor's extradition warrant being issued. We'll see what's going on when we come back to court on Tuesday. But there are ways for Chris to be released from custody here, to go on his own back to Texas, to appear in court and to fight these charges. And that's what we're hoping for.
Judge Ann Mormon was very reluctant to have any exchange to begin with. She told you, there's nothing I can do about this. And you were able to convince her that there was a pathway, at least for a hearing.
Yeah, the penal code is very, very hard to understand. I mean, I had to read this thing over many times. The language is very, very convoluted, and it dates back many years. And there's very little case law on this. There's actually only one important published California case on all these things. Judge Moorman had read the statute to apply when the fugitive is in another state and is actually a fugitive from California justice. Here we have the opposite, where Chris is accused of being a fugitive from Texas, and he's in California. And ultimately, I think I was able to convince Judge Moorman that penal code, those particular penal code sections, which do allow some possibilities, such as for habeas corpus petition, release on bond, or even ultimately discharge from the holding order, that law applies to someone in Chris's position. And ultimately, I think she came around to that viewpoint. I will say that she gave us precious little time to try and get a resolution to this that would be acceptable to both Texas and to me and my client. But we'll do the best we can within those confines. And my plan now is to take Judge Moorman very literally when she notes it in her past experience contacting the district attorney's office in Texas has had a positive effect. So first thing tomorrow morning, I'm going to be on the phone trying to reach the DA in Brown County in Texas to see if we can reach an accommodation.
You were given another hearing on Tuesday.
Yes.
Without a stay of extradition.
That's right. She would not stay the extradition.
So there's a little bit of Russian roulette in here.
Yes.
What are the advantages of Texas allowing for the delay?
There would be certainly a cost savings to them. Sending some officers out over the holiday weekend, presumably on overtime, is going to be very, very costly to them for what's basically a fairly modest charge, notwithstanding the huge potential penal consequences. Perhaps Texas will, if we can provide some assurances, would let Mr. Diaz give reasonable bail. His bail is now from Texas somewhere in the vicinity of $150,000, which I'm quite confident that is not doable for the family. I mean, even getting legal representation. I'm taking this case basically pro bono because I think it's the right thing to do, but $150,000 is just not going to be in the cards.
What are the precedents in a case of extradition where the person that another state wants is in such precarious health?
There's the In re Walton case in California, a 2002 case, as I recall, which refers to a fellow who the doctor said that he had less than a year to live on account of his full-blown AIDS. The LA County judge did not issue the extradition order, released him from it. The state appealed, and the Court of Appeal ruled that that health issue could not be resolved by a California court, that had to be raised in Texas, and therefore ordered Mr. Walton extradited. And again, as I was saying, there's very, very little published history, which is basically how laws are applied based on previous courts' interpretations of them. So we're all to some degree winging it here. But unfortunately, although California law provides us with an opportunity to raise a habeas corpus claims, the Supreme Court of the United States has so narrowed the areas one can challenge extradition on that habeas corpus, other than the question if they have the wrong person or that he never did commit a crime, or that the thing of which he's accused was not a crime in the state that's accusing him, habeas corpus is difficult to bring.